and welcome to everyone that's joining us today for this Contentious Clinic. We are discussing the interesting case of Bowser and Smith, and importantly, the key points that we can and should all take away from that judgment. Leading the march today is my colleague, Hannah. Hannah is one of our trainee solicitors here at IDR Law. I will also be dipping in periodically with the odd thought and discussion point, which we hope will keep everyone interested and engaged. So today we'll be covering, if we just go to the next slide, what we'll be covering is the facts of the case of Bowser and Smith, the judge's comments and the practical implications of those, the issues that can come up when dealing with an executor who may also have a 1975 Act claim. The webinar is expected to last around 30 minutes. We hope there'll be time for questions at the end. So if anyone is watching live, please do add those to the chat function and we'll pick them up where time allows. If there isn't time, and for those of you not watching live, we'll be in touch about those questions and answers afterwards. And so to begin, Hannah, thank you for sharing the slides. Would you mind setting the scene?
Of course. So you've probably heard of this case before, but we're just going to go through it, the facts of it. So Mr. Smith sadly died. We've got Mr. and Mrs. Smith. They were married in 2009 and they had 10 children altogether. The parties actually separated in March of 2019 as the marriage broke down. So they were going through the divorce proceedings, but actually these weren't resolved before Mr. Smith's tragic death in 2022. Shortly after they had separated, Mr. Smith actually made his will, which appointed Mrs. Smith and Mr. Bowser, who is a professional executor, as his executor and as executors and trustees. The estate was then to be divided between their 10 children upon attaining the age of 21. So as I put up on the slide, the net value of the estate was 1.13 million, and there was no provision under the will for Mrs. Smith, and obviously the divorce proceedings hadn't been finalised. So at this stage, obviously Mr. Smith died, and barely a week after his death, Mr. Bowser sent a letter to Mrs. Smith. I've set out on the screen parts of the letter, just to give you an understanding of the tone and what Mr. Bowser was effectively asking for in this letter, because I think it's quite important to see how, as we'll go through it, the communication deteriorates. So in the letter, Mr. Bowser set out there was no financial provision for Mrs. Smith, and that effectively if she wanted to bring a claim against the estate, she'd be well advised to renounce her position as executor of the will. So at this stage, there were no conduct issues. The letter on the face of it seems quite reasonable, despite the timing, perhaps obviously so close to the death of Mr. Smith. But what we want to understand is whether or not Mr. Bowser had a point in raising the issue of Mrs. Smith potentially being conflicted in her role as executor in bringing a 75 Act claim. So Cara's going to delve a little bit more into this point for us.
So this was something that the court carefully considered. They were provided with no leading judgments on the point. I suspect it's because no one had previously made it so far as to find themselves the subject of a reported judgment. However, the court was referred to a number of leading texts on the subject. So the White Book notes that there is no need for a spouse or civil partner to renounce probate or the right to letters of administration if such person wishes to bring a claim under the 1975 Act. And Ross on inheritance claims state that it is perfectly in order for a claimant under the 1975 Act to act as personal representative, and goes on to say that while it may be natural to assume that a personal representative in such a situation ought to renounce, there is no need for them to do so. However, an important point is from Francis on Inheritance Act claims, which adds a cautionary note where it sets out that it is for an advisor to ensure that a personal representative, whether claimant or defendant, can wear the two hats comfortably, and that the duties of the personal representative, especially during the litigation of the claim, are performed properly. Next slide, please. This was all agreed by the court. therefore confirming that there is no legal principle in place that requires a 1975 Act claimant to step down. However, as France's On Inheritance Act claims points out, a conflict can still arise, albeit potentially later, if the actions of the parties result in that same conflict. But this applies to both claimants and defendants. On a practical point, you need to carefully consider with your client, whether claimant or defendant, as to whether they can realistically keep their hats, being their roles, separate. And in all honesty, this is going to depend on the facts of the case and in all likelihood, whether there is any animosity between the parties. As was evident in the current case, with that animosity and a lack of trust in the deemed remaining personal representative, this can lead to difficulties in agreeing a way forward. Notwithstanding that, the risks in litigation are that you may have a judge that ultimately doesn't agree with the way you've acted, which is where conduct then becomes vital, as it's likely to fall under the court's microscope, particularly when dealing with cost, which, as you'll hear in a moment, was ultimately the issue before the court. So back to Hannah then, what happened next?
So Mrs. Smith, so far as Cara has explained, wasn't necessarily conflicted. It wasn't the end of it, unfortunately. Mr. Bowser hadn't had a reply to his first letter from Mrs. Smith. Understandably, she had 10 children, all quite young at this stage, so she'd have been very busy, and their father had just died. So Mr. Bowser followed up with another letter to Mrs. Smith some 3 weeks later. He reiterated the content of his first letter, but again, I've put it up on the screen and you'll see, I think there was quite a significant change in the tone, and the judge actually put it that this letter is what set the correspondence on a downward path from which it never recovered, which I think you can agree they're threatening to remove her, and an application to court only 4 weeks after the death of Mr. Smith. So moving on, the next step, or the next significant step that was taken by Mr. Bowser in the August was to issue proceedings and serve them on Mrs. Smith. I've set out the basis upon which he did so, and on the point of costs, he asked for his costs to be paid by Mrs. Smith, or if not, then provision to be made out of the estate. He also made, as well as his claim, an application for an urgent application for emergency relief to enable him to obtain a limited grant to take urgent steps in the administration and prevent Mrs. Smith from what he deemed interfering and intermeddling further. What I thought was quite interesting was Mrs. Smith's response to the claim. She basically set out her version of events, and she complained that she had found Mr. Bowser's behaviour towards her to be aggressive, abusive and intimidating. In her response also, and it was picked up in the judgment, she made it quite clear on a number of occasions that she was prepared to step down as executor, but as Cara alluded to in her segment, she didn't think that Mr. Bowser was the appropriate person to be left solely in charge of the estate. So Cara, what else do you think could have been done?
So although we've only relatively recently just ran through the facts, if I can just skip on to the next slide, essentially, I think it's important that we run through the timescales here, because they're really considered by the court as to help them understand the conduct and the way that this was taken into consideration. So we have, sorry, I'm not quite sure what's happened there. So error on slide, but essentially on the 29th of May, 2022, the deceased died unexpectedly. Within less than 2 weeks, the first letter is sent out, which Hannah says quite rightly was relatively normal in tone. It was just asking, what's your intentions regarding the funeral? What's your intentions regarding your executorship? No response to that. So a second letter is then sent out 3 weeks later with a significant change in tone, saying, this is what we're going to do. We're going to remove you. This is not acceptable. A couple of months, or not even a couple of months later, proceedings are issued. And then we've got an urgent application being made. So it all happened really very quickly. But in a sort of a breath of sympathy for Mr. Bowser, it does look like it appears he felt there was nothing further he could do. And so he chose to commence legal proceedings to remove Mrs. Smith as a co-executor to get the administration proceeding. He had a funeral that hadn't been dealt with. There were a lot of other factors that needed to be taken into consideration. So in a likely controversial comment, in my view, it's important to keep in mind that the court will always have the benefit of hindsight when making judgments. So although at the time, Mr. Bowser was sending these letters, it was likely that he was faced with pressure from other family members and the funeral arrangements for the deceased, as I've mentioned, as well as a need in this particular case for a farming business to be dealt with. It is something that you need to tread carefully with. And so while hopefully not the norm, it is not, unfortunately, an overly unusual position for an executor to find themselves in, to be tied up with all these conflicting interests. And so for those that do, the warning made clear with this case is to proceed with caution. So next slide, please. What is it you should actually do? Well, this will depend entirely on the specific circumstances of each case, but in general, it would be sensible to remove as much pressure from the situation as possible. This could be to focus on the funeral only in this particular instance, to allow everyone time to grieve, to put in place interim remedies for businesses to continue trading, and to seek advice early if it appears there may be a dispute. You can also consider whether to make alternate applications to the court, less aggressive, less hostile litigation applications, such as asking the court for directions in matters where there is or will likely be a dispute, such as in this particular case, whether the deceased should have been buried or cremated. Instead, Mr. Bowser went ahead and just buried, whereas there was an argument as to whether or not, cremated, as whether an argument as to whether or not it should have been buried. The party should also consider alternative remedies. It is quite possible, as it was in this case, for the person being asked to renounce to have concerns doing so, with the other person being left appointed. Think about whether another person can be appointed in their place. Could the parties appoint an attorney for the purposes of dealing with the estate? Could they both agree to be removed and be replaced by a third party? Because if they can reach an agreement, irrespective of whether they have intermeddled, a joint application can be made to the court to endorse their removal, which is much more cost effective than hostile litigation. And in those circumstances, the costs tend to come from the estate, as the parties are usually able to show that they're acting in the best interest of the estate and the beneficiaries as a whole. So then, Hannah, what actually happened in this case?
There was correspondence between the parties, and obviously the proceedings were issued and served. And I think the correspondence, and if you read the judgment, it does go into it in quite a lot of detail. It shows just how entrenched. I know Cora wants sympathy for Mr. Bowser. I'm on the flip side. I think he was quite entrenched in his position and showed no means of compromising. So then we get to the point where we have obviously Mr. Bowser's interim application, which was automatically listed for a hearing in September, but Mr. Bowser wasn't happy with this. He wanted a more urgent hearing, so it was passed to a listings officer, but it doesn't seem like any other action was taken until the directions hearing, which was listed in the November, which could be quite telling as to how urgent it actually was, or the court deemed it to be. So we're at the point of the directions hearing, which is quite a pivotal point. It was the point at which the judge ultimately guided the parties towards a resolution in terms of the actual disputed matters. The judge was concerned that if she were to agree to Mr. Bowser's interim application to remove Mrs. Smith, then again, as Cara alluded to, he would be left as a sole executor, and it could be acrimonious and ultimately lead to a trial whereby both Mr. Smith and Mr. Bowser would have been removed, only to then have appointed a third party independent PR. So during the hearing, the parties took some time to go and consider their positions in light of the judge's comments, and they ultimately came to an agreement for them both to effectively be removed and to appoint a third party independent solicitor. So it was all fine. The court endorsed the agreement, and then the only issue which was outstanding was the matter of costs, which the parties agreed to deal with later by submissions, as they hadn't come fully prepared to deal with the matter of costs at the hearing. So after the hearing, the judge ordered that the judge ordered an adverse cost order against Mr. Bowser. Ultimately, they decided that Mrs. Smith should be able to recover her costs from Mr. Bowser or the estate if Mr. Bowser, if these were not forthcoming from him. Mr. Bowser was removed of his indemnity to recover costs from the estate, and he was to make an interim payment to Mrs. Smith of £12,500 within 14 days. Mr. Bowser didn't like it. Obviously, he appealed the decision. The reasons the judge gave, which I thought were quite interesting for the adverse order, were the fact that Mr. Bowser didn't engage in pre-action correspondence. He didn't apply or consider a BEDO application. And ultimately, his action was unsuccessful. He wasn't successful in removing Mrs. Smith as executor. And the final order, as had been agreed at the hearing, was for both parties to be removed, which is what Mrs. Smith had suggested in her response to the claim. So it could have been dealt with way before this point. And I think that was one of the court's points as well. So Mr. Bowser appealed the decision, but ultimately his appeal was dismissed. So what we're going to look at is what the judge said and what we can take away, what lessons can be learned from this case, which I think Cara is going to kindly deal with. Next
slide, please. So the judge made a number of disparaging comments about Mr. Bowser's conduct, both prior to and during the litigation. I'm not going to rehash them all here. They're not on the slides, but it is an interesting judgment, so I would have a look at it. It is worryingly, in my view, not necessarily on Mr. Bowser's side, but I can see how he got himself into that situation, that it is worryingly all too easy. And so care should and will need to be taken to ensure those of us acting either as professional executors or conducting litigation on behalf of those acting as professional executors should take heed of some of the suggestions made by the court. So from reviewing the judgment, the key lessons that I think ought to be learned are set out on the slide here, but essentially seek to engage with the executors. I know in this case, Mr. Bowser sent a couple of letters, but there must have been other things that he could have potentially considered doing, picking up the phone, talking to family members. Was there an email address, something else that could have been done? And I think the biggest thing of taking away from that is not to immediately go with a hostile court application, but to say, look, this isn't working. We need to somehow work together, or we're going to have to come up with an agreement as to how we move forward. So we're looking at that conciliatory way of working together. That will be helped by careful drafting of letters. I think it's often easy to overlook the impact that a deemed technical term can have. In this particular case, it was the use of the word intermeddling. Although we use it very often in the legal profession as an executive is intermeddled, therefore they can't renounce. Actually, it has quite a negative connotation attached to it. It sounds like they've done something wrong. So the layperson might be inadvertently upset by that and take offence, and that can then add to a hostile situation. Also, you need to be careful about taking a general aggressive approach, which in this case, it escalated quite quickly. It went from, please tell us what your intentions are, to we're removing you and we're going to go through the court and get our costs. There's quite a jump between the two courses of action and suggestions taken there. There's also the, as I've just touched upon, the need to work cohesively in estate litigation generally. All of the Act Out's Code of Conduct and the rest of it will deal with that. I'll come to those in a second, though. The other thing to do that's on the slide is allow time where possible. Don't rush, don't be forced, as I've mentioned earlier, don't be forced into making decisions very quickly. It's not always possible. Sometimes you have to if there's other things happening, such as in this particular case, a business that at the time it felt like needed some urgent attention. But in those situations, consider the grieving process and consider other applications that can be made. I touched upon it earlier, but your CPR Part 64 applications, your please court, tell us what we should do in this situation, can be incredibly helpful in resolving a potential dispute without adding it into a hostile situation. As I say, consider the grieving process. If you have to embark on the litigation, definitely consider seeking protective relief, such as a bedo order. The process of considering whether a bedo order is appropriate and then going through with that application is quite arduous. And so that alone would give a person reflecting an idea as to whether or not it really is in the best interest of the estate to conduct the litigation they are contemplating. And the last resort ought to be litigation. If you have no other option, then fine, that is clearly what must be done. But you have to, as you set out on the slide, you have to comply with the pre-action protocol and actually send those pre-action letters. And the one takeaway from all of that is if you don't do all of those things, or if you don't do them more carefully, and or you ignore them all, then you are left in a situation where you may find yourself facing an adverse cost order and or be relieved of your usual indemnity to recover costs from the estate. This being unless you are able to show that it would be manifestly unjust for you to have that relief removed. But in this particular case, the court have reinforced this and said it's a very high bar, so it's best to avoid getting yourself into this situation. We've got two very quick slides that follow on that I'm not actually going to go into detail of, but if Hannah could just flip through them as I'm speaking. The approach generally that I've just discussed is confirmed in the ACTAP's Code of Conduct, basically try and avoid hostile litigation, even where litigation is necessary, essentially work together to try and come to some sort of conciliatory approach with some sort of agreed outcome. And then we've also got the pre-action protocols. There's a couple we've put on there. There are others, of course, which are there to help parties in this particular instance understand where they may be facing their own position of conflict. For example, in circumstances, and as was the case in the Bowser matter, where they're reluctant to release relevant files for fear of the implications that may have, that's an indication in certain circumstances that you might be putting yourself into a position of conflict, and therefore you need to consider what you should do and whether there is other course of action or whether someone else ought to be appointed. So, Hannah, this appears to be a rather radical approach by the judge, removing a person's cost security from cost indemnity. Is it a radical approach, or is it the new norm?
I'll unmute myself, that helps. I think it might be the new norm. There's a more recent case, it was, I think, October of this year, basically just reaffirming the court's approach. I've set out briefly the facts. Again, I think it's quite a good judgment to read. It was primarily on the point of costs. And just briefly, I know I'm not sure how we are on time, but the executors were effectively the claimants in this one, and the claim to prove the will, which failed in part at least. That's why it's quite an interesting judgment. And the residue fell to the deceased children. Again, read it in detail. I'm not going to bore you with it now. But basically, in terms of the costs, the judge found that by actively pursuing the claim, the executors, that is, rather than taking a neutral stance, they were not found to have acted in the benefit of the estate, but for the benefit of one of the executors who had a financial interest in it. So what it meant was that the court exercised its discretion and found that the executors had to effectively pay the defendant's costs out of their own pocket. So it just reaffirms the fact that the court can and will exercise its discretion if the executors don't act neutrally. And I think that, as you said, when we're advising executors in litigation, obviously to advise them on these points and specifically on the risk of costs.
Fabulous. That does bring our general discussion to an end. If there are any questions, then please do add them to the chat and we'll work through them now. I think we were running a little bit late, so we've got a couple of minutes. I think if anyone doesn't mind overrunning by a couple of minutes, but otherwise, if there aren't to be any questions, I'll just give it just a couple of seconds to see if there is anyone. We were relatively lucky with this one in the sense that it is a surprisingly short judgment, despite being about 29 pages long, but it is one that is interesting, and Hannah and I have both said throughout this that it'd be worth having a read because it shows a turning of the tides, for want of a better phrase, that executors and trustees actually do need to act really cautiously, especially if they don't have a vested interest in the estate themselves, in embarking on hostile litigation against those that do have a vested interest in the estate themselves. And it can result in this situation with not only adverse cost orders, but that removal of their indemnity. So the cost risk is and can be quite high. So I can see that there are no questions. So, if anyone thinks of anything in the future, please do let us know. But if I can just jump to the last slide, I just want to say thank you to everyone for joining us today. We hope you did find it useful. We're taking a break on the Contentious Clinic in December. So please do keep an eye on the IDRN for upcoming webinars and podcasts. The IDRN link is in the chat. Thank you, Lindsay. And we'll be back with the clinics in January. So thank you again to Hannah for all of your efforts and your review today. And to everyone else, until next time, thank you and have a lovely rest of the day.